Okay, hi everyone. Thank you. We took a couple minutes just because there are more people that are pouring in. Thank you for joining us for today's webinar. We had a huge interest in this topic with lots of questions, and we're thrilled to be able to help. So my name is Beth Cohen-King, and I'm the Marketing Director at Margolis Bloom. We work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to this effort 30 years of experience and a commitment to providing the highest level of personalized service. So today's presentation is going to be by Sarah Hartline. She's a senior associate at Margolis Bloom. A little bit about Sarah. She represents clients in estate planning with a focus on long-term care and special needs planning. She also represents clients in guardianships, conservatorships, and probate administration. So we're so excited for her to share her knowledge on irrevocable trusts in regards to MassHealth eligibility. As usual, if you have questions, I'm just gonna go forward a second. There we go. There's our mugs. As usual, if you have any questions during the presentation, please type them into the question box in your control panel on the right side of your computer, and we will have time for some questions at the end. But if we don't get to your questions, we do get a printout of them, and so we will follow up as long as we have your email attached to it, which I think it does pull up. So we will follow up if we don't get to them. And with that, I want to turn it over to our presenter, Sarah. Take it away.
Great, thank you. Good afternoon, everyone. Sarah Hartline, and today I'm going to be talking about updates on the treatment of irrevocable trusts, specifically in the context of MassHealth long-term care eligibility. So, and when I've presented on this topic in the past, I typically ask for a show of hands to see whether people are already familiar with the topic or not, and I usually get a mix. So I'm going to start with an overview of the basics for about the first half of the presentation, reviewing the cases to date in the past 10 years, and then the second half will more focus on the what to do about these types of trusts, whether or not practitioners should still be using them, what are some alternatives, and what to do about existing trusts that might have some problematic provisions in them. So the first big question, should we still be using these trusts, irrevocable trusts? Can someone use an irrevocable trust and still qualify for MassHealth long-term care benefits? And the answer is yes, based on the regulations and the recent case law. They both recognize the use of irrevocable trusts for MassHealth planning purposes. And there are some basic requirements, though, that you're going to need. First, the trust must be irrevocable. Second, the transfer of assets into the trust must have occurred at least 5 years prior to the MassHealth application for benefits. And third, the trust must prohibit distributions of trust principal to the applicant and his or her spouse under any circumstances. So that's the most important part. All three are important. I would say the third one is the one that can get the most complicated in terms of somebody drafting an irrevocable trust for Medicaid planning purposes, how to make sure that the trust prohibits any distributions of principal to the applicant. So like I said, there are those three basic requirements, and it can seem pretty straightforward in terms of someone drafting a trust that you need to include that language. The trustee can't distribute principal to the applicant and his or her spouse under any circumstances. However, in the Doherty case, which is a 2009 case, as you can see, there was sort of made it a little bit more complicated. That case, in terms of for people that are drafting these trusts, that case made things a little bit more complicated because in the Doherty trust, it did have that explicit language saying that trust principal could not be distributed to the applicant under any circumstances. However, MassHealth determined that there was other language in the trust which gave the trustees certain powers, among other things, to terminate the trust and distribute assets out to the beneficiaries. And MassHealth interpreted the applicant to be a potential beneficiary. And so basically, even though the trust was saying in one section that principal could not be distributed out to the applicant, MassHealth's argument was there was other language in the trust that could be potentially interpreted as giving the trustees powers to get principal out to that applicant, and therefore the assets in the trust property, is countable in terms of that applicant's MassHealth application. And the court in Doherty did uphold that interpretation, and saying that really the trust has to be looked at as a whole when you're determining whether or not the donor can access principal. So that's the language that the court used, viewed as a whole, talking about saying not only do you have to have that language in one place saying that principal cannot be distributed out to the applicant, you also have to look at all that other language in the trust and see if there's any other way that the trustee could potentially distribute property out, that the applicant could potentially access those assets. And so following Doherty, which was in 2009, MassHealth is, there's two more cases, Hine and NATO, that come later on, but in between those cases, MassHealth is really making a lot of these increasingly creative arguments about how language in these Medicaid planning trusts, language that some people might see as sort of meaningless boilerplate language, could actually be twisted in a way in which the trustee could arguably use those powers to distribute principal out to the applicant. And therefore, under this Doherty case, even though there's an explicit prohibition of principal, these trusts could still be considered countable assets, again, for this MassHealth long-term care eligibility purposes. So the next two cases, as I said, the Hine and the NATO case, these cases tested a lot of those arguments that MassHealth was making. So in some of these, where there was a MassHealth application, the applicant had one of these trusts, which, for example, might have had a piece of real estate in that trust. MassHealth was saying that trust, that real estate is a countable asset because it's in this trust, and this trust has certain language, and they were saying that there might be even several provisions within that trust which they saw as allowing for access to principal and therefore making that trust a countable asset. So in the Hine case, which was decided in 2016, the court actually addressed three of these different arguments that had been made by MassHealth for a few years leading up to this 2016 court case. The first argument is the so-called annuity argument, is an argument which MassHealth was making, saying that if the trust allowed for distribution of income to an applicant, but also allowed the trustee to purchase annuities, it allowed indirectly for the trustee to distribute principal to the applicant because the trustee could purchase an annuity and therefore convert principal into income. So any of these trusts that had both a right to income and allowed the trustee to purchase annuities, again, would be a countable asset. And the court in this case did very explicitly reject that argument. They said that was, once the principal is converted into an annuity, what the applicant is receiving is income, not principal, and they did very clearly reject that argument. The court also went out of its way to address and reject two other arguments that MassHealth had been making. One was an argument that focused on what's called the lifetime power of appointment, in this case to individuals. And that's a provision in a trust that says while the applicant is living, the applicant donor is living, they can appoint trust property not to themselves, but to another individual, like a descendant or child.
And sorry, by property, do you mean real estate or?
Sure. So when we're talking, I sort of use those terms interchangeably: trust property and trust assets. But in either case, trust property or trust assets, we're talking about any of the, whether it be real estate or financial assets that are owned by the trust, whatever was used to fund that trust. And like I said, the lifetime power of appointment to individual means that, for example, if it was financial non-real estate assets that are in the trust, the donor applicant would be able to appoint portions of that property to, or even the entire property while they're still living, to individuals other than themselves. And the argument that MassHealth had made was that because the donor could appoint it to someone else, such as a child, and that child could then transfer it back to the applicant, that was a way that the applicant could still access the principal, even though it was indirect. And the court did reject that argument as well, saying that the trust property had to be directly payable to the applicant, and this sort of indirect path was not a reason why the trust should be deemed, like I said, a countable asset. The other argument involved the power of the right of substitution, which is a provision in many of these trusts that allow for an applicant to substitute other assets. So, for example, if there was real estate in the trust, the applicant could substitute that with real estate that has an equivalent value. And again, MassHealth was saying because the applicant could substitute other property and then access the property that was in the trust, that again would be a way of accessing principal. And the court rejected this argument as well, because of course, even though the applicant could access that real estate by substituting something else, they would have to substitute something of equivalent value. So it would just be the same as purchasing the property from the trust. So that was the Hine case in 2016, which, as you can see, overall, that was definitely a victory in terms of these types of trusts being continuing to be viable, because three of these very common arguments that MassHealth is making were all rejected explicitly by the court. The next major case after Hine was the Daly case, which was decided in in 2017. And the focus of this case was on the use and occupancy provision, which again is commonly in these types of irrevocable trusts. So if somebody often is, because as I mentioned, often people are transferring real estate into these trusts, the idea is that they want to, even though they're giving up access to the equity in that property, they still want to, if it is their primary residence, they still want to live in the property. They don't want the trust to basically kick them out of the property if, for example, it's their home. So commonly when people were drafting these trusts, they were including a term that says the donor can use and occupy the property after the transfer is made. And MassHealth sort of jumped on that provision in particular to say, well, if the applicant can still use the property, then aren't they still accessing those trust assets, basically? Isn't that the same thing? And the court said no. They vacated the MassHealth judgment in this case because it had been based on that use and occupancy argument. However, it did remand the case back to MassHealth because of to other provisions that were in the trust, which the court said could potentially be problematic. One of those was the charitable power of appointment, which this is similar. I talked about the power of appointment earlier, where the donor had the ability to appoint property to an individual. Here we're talking about the ability for that donor to appoint property to a charity, again, while they're still living. So they can't access the property for themselves, but they can appoint it to a charity. And the reasoning that the court used for saying that this is problematic was that they said if the applicant had this ability to appoint property to a charity, why could the applicant not appoint property in the trust to a nonprofit nursing home if they needed long-term care, and therefore basically use the power of appointment as sort of a way of paying their long-term care costs by appointing it to the nursing home.
So would it make sense here then to define what charity you want, or does it not need to be in the trust if you're going to define the charity that you're going to give to?
Well, so I mean, one of the problems with that argument is that just there is a difference between a nonprofit. A nonprofit nursing home is not necessarily a charity, and so that's so there's a few different problems with the argument, but that actually is one of the issues, and I mean in terms of how how it should be worded in a trust, for many applicants they actually don't even need this power. So I'll talk a little bit later about how to structure these trusts going forward, but for some clients, they might not need a power of appointment to a charity, and so the solution might just be taking it out altogether. The other argument that the court said was the other provision that the court said was potentially problematic was the grantor tax language. So this is language that's in the trust. Again, it's standard language for this type of trust that says that if the trust owes a tax, that the trustee can use trust principal to pay for that tax. So again, the court said that this was potentially problematic because, again, the principal is being accessed and sometimes paid directly to the donor in order to pay these taxes. But there was an important caveat, which was that if MassHealth was going to count this, use this to count part of the trust property, it would actually have to calculate exactly how much of the trust property could potentially be accessed for that purpose of paying taxes. And what we've seen in a lot of these cases, hearing decisions that have come out since this time, is that MassHealth is really struggling to do that, to calculate exactly, if a trust says part of the principal can be used to pay taxes, what is the exact amount of that principal that could be used to pay taxes? It's a hard calculation to make, and often MassHealth is unable to do that. So that has been, like I said, an ongoing issue that's still up in the air, both the charitable power of appointment language and also the grantor tax language. And then I'll just mention one more recent case, which is actually a New Hampshire case, but it's a case that's cited frequently by MassHealth. It's the Braderman case, and this is actually, in this case, the grantor had an ability to, it had a power of appointment, but it had also the ability to condition powers of appointment. So, for example, the grantor could say, I'm going to appoint trust property, the grantor could appoint trust property to a child, but also include a condition that property would need to be used for the grantor's benefit, for example. So the court found that this power did make property countable because of the fact that the applicant could manipulate it in a way in which it could basically make these distributions while at the same time requiring that it be used for the applicant's benefit.
So in this case, leaving out the conditions, would that potentially change the outcome of the case?
Right. So that's the big question, is that in this case, because it was not just a power of appointment, the grantor had that additional ability to condition it. MassHealth, we would argue that is different than just having a power of appointment. It's an additional special authority. And would distinguish a normal power of appointment from this type of case. Whereas MassHealth has, since this case, has frequently been citing it to support their position that basically all powers of appointment should make trust property countable, because they see this as evidence that just because the property can't be directly paid to the applicant, it can still result in the trust being countable if it can be used indirectly for the applicant's benefit. So that's a review of, like I said, some of the important cases in the past 10 years on this topic. And so that was a lot of information. And what does that all mean? And where does that leave us in terms of, should we still be using these trusts? It's sort of, like I was saying earlier, a game of whack-a-mole where, these arguments are coming up for MassHealth, then they're going up to the Superior Court, which is knocking them down, but then, 3 more arguments pop up, new arguments pop up by MassHealth, and so it's sort of a back and forth of trying to knock down these different arguments that MassHealth is making. They clearly don't like the use of this type of trust in the context of Medicaid planning. So what we did is that we took a look at these Board of Hearings cases since Doherty between 2009 and 2016, and then also looked at some decisions in the past year to see in terms of denials and approvals, to get sort of a sense of where we stand at this point. And so what we found was that very few cases now that have MassHealth applications that involve this type of trust are being approved at the application level. Most of the applications are denied, and there's a need for the applicant to appeal to the Board of Hearings. But at the Board of Hearings level, there actually are still a lot of approvals, even if the applicant has this type of trust. So getting into some more specific numbers, so this is post-Doherty, between 2009 and 2016, we looked at 112 Board of Hearings decisions where a typical Medicaid planning irrevocable trust is involved. And at the hearing level, 53% were denied and 47% were approved. So, and this is not very scientific. We just picked out these random 112 decisions, but it shows that during that period there was sort of about a 50-50 chance of the application ultimately being approved. Then we looked at, just in the last year, 22 Board of Hearing decisions, again with this typical Medicaid planning trust setup. And of those 22 cases, 73% were approved and 27% were denied. So, thank you.
Sorry, little delay.
73% were approved and 27% were approved. So again, these are obviously very small sample sizes, but I do think that it shows that this type of trust is still a viable option for Medicaid planning purposes. As long as you are structuring it the right way and making sure to, when you can, take out those potentially problematic provisions. So We also looked at the denials and took a look at what are the most common arguments that MassHealth is making in these cases when they are denying the application involving one of these trusts. And so, so the first argument is the potential income argument, which is an argument that basically any of these trusts that have a right to income should be counted as assets because, and it's a little hard for me to explain this argument because it's in some ways very much contradicts the actual regulations, which say that income is not counted in determining whether somebody is eligible. But basically, the argument is that that right to income itself alone, because of the potential income that could be generated by the trust, should mean that the trust is counted. And this argument was specifically addressed and rejected actually in a Worcester Superior case named it's the Hopper case. But we have seen that again in these most recent decisions that this argument continues to pop up. So the second argument that we see is, as I mentioned before, the Braidman argument. So this is the New Hampshire case, the argument that the power of appointment, basically any power of appointment can make trust assets countable, even if it does not allow direct payment to the applicant. The third is the charitable power of appointment argument. Again, we discussed this in the context of the Daly case. MassHealth is continuing to make this argument that trust property could be appointed to a charity and could potentially be appointed to a nursing home, and therefore this provision within a trust is reason to deem the trust assets counted for purposes of the application. And then the fourth and fifth arguments involve grantor tax language and trustee compensation arguments. Again, the grantor tax language argument we talked about in the context of Daly, that the principal is countable because it can be used to pay taxes. Trustee compensation argument is similar in that if the trust has no prohibition on the grantor serving as trustee and the trust allows for the trustee to be compensated with principal, the grantor could potentially be compensated with trust principal for, again, just these hypothetical potential trustee services, and therefore, again, principal is accessible to that applicant. So, given that MassHealth is, like I said, making these arguments, has this whack-a-mole approach, what's the best way to draft these trusts going forward? And the answer, which might be sort of obvious, is to basically omit any of these provisions that are not absolutely necessary. And so can you omit, for example, the trustee compensation provision? Is there any reason that you need that? Can you eliminate the right to income? And in some cases, the answer is yes, and then in some cases, depending on whether or not, for example, the applicant needs that right to income, that's something that they're depending on, then the answer might be no. So it's all about really structuring that trust, depending on the client, what the client's needs are, but then also eliminating what provisions that you don't need. So unlike when you're normally drafting a trust and you sort of just include all of that boilerplate language, just in case that becomes an issue where, when you say whatever the provisions may be, this is a case where you really want to tailor it specifically to the client. And in some cases, so this is just talking about what can be omitted. And then in some cases, you want to also look to alternatives for the client. So is a life estate more appropriate? Are outright gifts more appropriate? Is there, there are risks with that approach of just gifting the property, but maybe the MassHealth protection is the most important goal, and they're not as concerned about they might not be as concerned about the step up, for example. So again, these would be all different things to consider.
The step up?
So the step up is in terms of the tax treatment. So one of the reasons why the advantages of using an irrevocable trust is that if when the property is transferred into the trust, you can still maintain what's called the step up in basis, which is when the applicant is to pass, the basis for capital gains tax purposes will be the valuation of the property as of the time of the applicant's death, as opposed to the time when the property is purchased. So again, when you're weighing this, one thing you would be looking at is what's the, when the property was originally purchased, what was the valuation, and has there been a huge increase in valuation over time where it's really important to maintain that step up, or is it something that the client is willing to forego? So, and then finally, since I'm sort of running out of time, go a little more quickly. In terms of existing trusts, what to do about an existing trust that has already been drafted, or perhaps it's your trust, where it has some of these provisions that may or may not be problematic. And there's a few different possibilities for fixing trusts. I've listed a few here, such as executing a waiver of powers by the trustee, a formal trustee reformation process with the court, or a transfer of the property to a new trust, perhaps via a non-judicial settlement agreement. So again, there are a number of different ways, depending on the client's situation. Do they anticipate that they might be applying for MassHealth benefits in the near future? Is this more of like a long-term concern where they're not concerned about the 5-year look-back period? And I guess, and again, I'll sort of go to the next.
Yeah.
Oh, sorry, go back. And so then one of the questions is, in terms of the 5-year look-back period, is actually, if you are changing the trust or transferring it to a new trust, is there that risk of starting a new clock? And you could argue that logically, if the trust is defective or countable, then you're better off transferring the property to a new trust, even if it means starting a 5-year look-back clock, because you're still in a better off position. And if the trust was not defective or a countable asset, then you won't be starting a new clock because the assets were already outside of the applicant's reach. So so it's possible that there really isn't. You could argue that there isn't any sort of risk to reforming the trust or transferring it to a new trust, but it's just hard to know because we haven't seen how MassHealth would treat these transfers, if they would still make that argument somehow that would be problematic in terms of reforming the trust. Just the fact that the trust was reformed, or the fact that there was a non-judicial settlement agreement, if they would make those types of arguments that those processes in and of themselves have some effect on how the trust assets are going to be treated. So
just a general trust estate plan, how often do you think it makes sense to then review this, especially if you are potentially getting to a stage where applying for MassHealth benefits or the community benefits is going to be important?
Sure. So in general, we say that just estate planning in general, it's a good idea to review your plan every 5 years, or if there's a major life event, if there's a major change in somebody's health, those would be all reasons why you would want to meet with your attorney and have your trust reviewed and see if it makes sense to do something about the existing trust that you have, or based on how it's structured, what the provisions are. But it is, it's always changing. There's always new cases. There's always new potential issues. So it is something that, I would say, every 5 years it does make sense to touch base with an attorney and take a look at it and see not only how that trust is, but to take a look at the rest of your plan as well.
Okay, great. So Thank you, Sarah. I'm going to take a look at the question panel, see if we have anything. This is definitely complicated and I'm sure nerve-wracking. Even just getting sort of a periphery understanding of it is a challenge.
Yeah, it's a lot, and so yeah.
So with that, Sarah and the firm were available to answer additional questions. I put Sarah's email there. So if you need any, here's our contact information for any additional follow-up. And we are going to have a recording of the presentation. That should be available within a week. So if you weren't, if a family member you think this would be valuable for, you want to pass it along to a colleague, we will have it available. So check your email, and the recording will be there. It will also be available on the website under the webinars and events section. So with that, let me see if I can see any. Okay, here's this one. We will post this. Well, you will post the video. Someone asked, are we posting the slides anywhere? We'll have the video, so you can use that. And then, let's see. If a life estate is allowed, what is the argument about use and occupancy that MassHealth was making? Can't see the rest of the question here.
Is it likely? Well, I think I can address what I.
Oh, is it?
Maybe likely a problem in the future.
Is it? Yeah, I think so.
Okay. So actually, in the daily case itself, there was actually a discussion on both use and occupancy and life estates, and so the sort of the short answer is that the court determined that use and occupancy was not a problem, and that also that life estates, because they are specifically allowed by MassHealth, wouldn't be problematic. So I guess my answer would be that that we don't see that as being a concern, but of course we can't predict what MassHealth will do, or if there could be a change with regulations at some point. But yeah, I wouldn't anticipate that being a problem anytime soon.
Okay, so if a trust grantor is deceased and trustee has total discretion to distribute income or principal, will this qualify for MassHealth?
So I'm not sure I understand, because if the grantor is deceased, I'm not sure who in that hypothetical is the applicant. If it's the, but maybe that would be, if you could maybe. Oh, this is a different question.
Yeah.
Oh, okay. Yeah. So in that question, maybe if there's just some clarification on who's applying for it, if that person that's applying is the beneficiary of a trust where the grantor is deceased, or if it's, so maybe some clarification on that. And then to avoid income issues with irrevocable trust, is there a problem?
This just doesn't work that well. Okay, to avoid income, is there a problem? Is there an issue with deeding the home to a straight irrevocable trust and grantor retain a life estate? Retains the step up.
Right. So so that is, so one option is to grant the property to an irrevocable trust and retain the life estate in order to maintain the step up. So so that would be, so that's definitely one option. And again, it just, you have to just do the sort of the weighing for each of these options. There's the pros and cons to doing it. So it really just depends on, one issue with the life estate would be if the property is going to be sold at some point, or if the family, if that's something that that's potentially they're going to sell it, then the life estate could be a potential issue. Whereas if they have no intent of selling the property at any point while the applicant's living, then that's not, that's less of a concern. So again, really specific to the client's situation.
Okay, so there are more questions I see here, but I think we've run out of time, and I will pass these along for Sarah to answer. She'll
Okay.
get to you by email with those. So thank you again. Thank you for tuning in, taking time out of your day. We will have the recording. I did see that there was some questions about the slide presentation.